It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my canonical co-host, Brett.
Alice, I love how appropriate your descriptors are. You know, I just try and come up with random words to describe you, but yours are always on point. And
Well,
man,
Brett, how often in life can I use the word canonical to describe you when today is like the day we law nerd out and get to talk about canons of construction? You have to use canonical. It comes to you. It's the way it should be.
The fact that anyone listens to this podcast is kind of shocking.
I don't know that anyone does.
Oh, well, this might be the end of it. And people may listen to this episode and be like, what am I doing? Why am I doing this? Because today, as Alice said, we are going to talk about interpreting statutes, which is about the nerdiest thing ever. But, you know, I mean...
But, Brett, also, what could be more important, to be totally honest, right? Like,
that's true.
Because we all talk about, oh, what law did they violate? You know, what does the law say? We've talked about the elements you have to prove and what is reasonable doubt. But at the very core of all of that, if there is no statute that's being violated in the context of criminal law, then you have nothing. You know, we don't run by kind of mob rule of what we think justice feels like in the air. It's all down to what the words of the statute say. And so therefore, interpreting statutes is really important. And you all may think we can read, that's how you interpret a statute. But nay, it gets much more complicated.
Nay. See, really, we're giving you all our secrets. Like, we're putting ourselves out of a job by telling you how to do all this stuff, because Alice is right. I mean, there's a lot that goes into this, and you would think, given the fact that what a statute says can result in you being put in prison for a very long period of time, that there would be sort of a standard, everybody agrees exactly how we're going to do this. And yet, nay, as Alice says, nay, that is not the case. So this is both to sort of give you an idea of what people are talking about sometimes. You know, when there are particularly controversial things going on with the Supreme Court, or maybe a Supreme Court justice is being confirmed, or something's being debated, a lot of this stuff will come up, and this will give you some familiarity with the vocabulary and the way that you can look at statutes. And every now and then in true crime, people will actually try and look at statutes to figure things out. Remember back to the West Memphis 3. We talked about this habeas corpus statute in Arkansas, and people were trying to figure out, do you have to be in custody or not? And they're looking at the statute, and they're doing things like pulling one section out of the statute and saying, see, this seems like you don't have to be, so therefore you don't have to be. And that's not how you do statutes. It's not how you read statutes. And we're going to talk about some of that today. So this might actually be maybe, I don't know, possibly one time in your life you will use the things you learned today in your life. So that's better than most of the classes in school, right? I mean, whoever uses trigonometry, not me.
Yes, I will say, even though this is going to be nerdy, it may actually be one of those encyclopedic bookmarks that you put when it actually matters to you. You will come back to this and be like, that's what they were talking about. And in fact, it is helpful in my life.
So the first thing we're going to talk about are theories of statutory interpretation. And this is another thing that's at least one class in law school, maybe more. But we're going to start with theories, and then we're going to talk about some of the canons, canonical, as Alice said, the canons of construction, which are sort of the rules that you use when you look at a statute. And we're going to have a sample statute, and it's going to be no pets in the park. That's our statute. No pets in the park, which seems pretty straightforward, right? But the problem is there are like 6 or 7 different ways to look at this, and we're going to show you how no pets in the park can turn out to mean a bunch of different things. And why this is important is because most statutes are nowhere near that simple. Most statutes have ambiguities, they have confusion, interpreting them one way can have a massive difference in the way normal people's lives are affected. And so judges will often be faced with trying to figure out what exactly does a statute mean, because statutes bind people. And like I said, they can put you in jail, they can limit the things you can do, they can take your property. There's all sorts of things a statute can do. So getting it right is important, and sort of figuring out how we're even going to think about it is important. So let's start with the statute, no pets in the park. The first theory of interpretation we're going to talk about is textualism / originalism. Now, I put these two together because there's sort of an ongoing debate about whether they are the same thing. I think a lot of people think they are the same thing. I actually don't think they're the same thing. Usually you hear textualism when statutes are involved and originalism when the Constitution is involved. But for the sake of keeping things simple, we're going to consider these two together. So what does this mean? So it means that the words in a statute are given their ordinary meaning at the time they were adopted. So when the statute comes into effect, whatever the words of that statute meant at the time when the legislature got together and decided to bind the citizenry with this statute, that's what it means, and that's what it's going to mean for all time. And if you want to change it, you have to actually go back in and change the words of the statute. Now, that doesn't mean that nothing can change. So, for instance, the word pets. So imagine that when the statute was passed, the word pets meant certain animals, and there were other animals that weren't considered pets. Well, nevertheless, in the future, pets is still going to be animals that we consider pets. So animals that we have for recreation as opposed to work or whatever. And whatever animals are included under that would still be included by the statute. So even if certain animals weren't considered pets at the time, if they're pets now, they would be banned from the park. And this is one of those things that's kind of a misinterpretation some people have when you talk about textualism or originalism. They think that it means that it's absolutely bound in the time, and therefore, how can we ever use it to understand anything? And a good example of this would be the First Amendment. So you have a First Amendment right to a lot of different things. Well, when the First Amendment was enacted, we didn't have cell phones. So how in the world can we apply the First Amendment to cell phones? Well, the way you do it is you look at the way the First Amendment was applied to the things we did have, and sort of by analogy, you use that to determine what the First Amendment covers when it comes to cell phones. So that's how it works. It's the same principle. The words mean the same thing, but they can cover things that maybe weren't contemplated at the time.
So, for example, let's say when the statute was adopted, no one had donkeys as pets. Donkeys were only used as work animals on the farm. But let's say 30 years from now, there is, a huge wave of love for pygmy donkeys. Everyone loves tiny little donkeys, and every kid has to have a pygmy donkey in their Easter basket. And never before this time had donkeys ever been considered a pet. But now everyone recognizes on social media that this is the hottest pet to have in 2055. Then that donkey, even though originally when the statute was enacted would not have been considered a pet, would be covered by the statute 30 years later when it's accepted it's a pet. Another theory is purposivism. The judge looks to the purpose writ large of the statute. So what's the purpose of the statute? Can you bring your goldfish to the park? I mean, it is a pet, so no. But under the purposivism approach, the judge might look to the purpose of the statute. So maybe the purpose of having no pets at the park is to prevent bites, fights between cats and dogs, bothersome noise, animal waste. And none of these purposes are served by preventing you from bringing in your goldfish in a container that is sealed. So, under the purposivism theory, your goldfish would be allowed because the purpose of the statute is still held up even though you bring your goldfish.
And I think as we go through these, you'll see a lot of this sort of depends on what your view of a judge is and what a judge should do. If a judge just calls balls and strikes, for instance, if a judge is a very sort of narrow person who's really their job, take textualism versus purposivism. If you think the job of the judge is to read the statute and figure out exactly what it means, then you might say textualism's the way to go. And sorry, no goldfish. Goldfish is a pet. You can't have a goldfish. Very simple, very straightforward, right? But if you think, no, judges are more, their job is more flexible than that. And they are more of not just an interpreter of the law, but sort of in a higher place than that. You know, they're more philosophical, more interpreting sort of the law in its higher form. Then you might say, yeah, having the judge sort of take a common sense approach to this and say, look, what was the purpose of all this? I mean, you say pets, it's a pet, but that wasn't the purpose of this. And I'm not going to restrict you from having a goldfish just because the law says so. And that's sort of, what do you think a judge should be doing or shouldn't be doing? And as we sort of go through these, I think you'll see that a lot of it just depends on sort of how bounded do you think a judge should be by what the legislature and the executive are doing. So the next one might be called pragmatism. Pragmatism may be sort of the broadest of all of these. And in that, you interpret the law through a pragmatic lens. And you're kind of doing the best you can given the circumstances. And this is sort of approach recognizes that life is really messy and legislatures do the best they can, but often things just don't work out and they're not as simple and they're not as straightforward. So you might have a place where people traditionally brought dogs to the park. And they always brought dogs to the park. And it was just sort of understood that whatever the law says, they're going to be able to bring dogs to the park. And so you might have a judge who suddenly, for the first time, this law is presented to him. It's like, look, people have been bringing dogs, but the law says no pets. Well, the judge might be like, you know what? I'm going to decline to interpret it that way. I'm just going to say that pragmatically, given the way things have always worked, that's clearly not what the legislature wanted. It's not what the law means. And so we are not going to enforce it that way. And pragmatism is really about enforcement. It's kind of the idea that if the police stopped everyone who sped, they'd be stopping people all the time. So you really only stop people when they are going very fast over the speed limit. So it's this sort of, we're going to kind of adapt to the circumstances and kind of go with the flow and keep things under control, but maybe not enforce the law as strictly as other people might think you should.
We are moving through these theories, and I know you are riveted. And stay with us because there are a couple more, and you guys have probably heard of these before. And if anything, each of these should resonate with you because they come from kind of our everyday life, you know, pragmatism, how we view kind of disputes in our own life, how we view how to settle them. Now, another one that you may have heard of if you've ever watched, you know, like any sort of congressional hearing is legislative intent. So a theory of interpretation being legislative intent. The words under this theory are interpreted based on what the legislature intended them to mean. So it's kind of an existential question. What are pets anyway? Is a horse a pet? If that question came up, then the judge might look at the arguments in the legislature, because when a law is passed, there's typically more than just what's written down on paper. There's usually time for debate. People get to talk about, you know, why they support the bill, why they're against the bill, and, you know, asking for changes in the final bill. And usually the person who's sponsoring the bill will make some sort of speech about how important this piece of legislation is. So imagine the sponsor gets up and says on the floor, this is a great bill that will keep pets out of the park, making it much nicer for all the horses in our beautiful town. Under this approach, the judge would look to that statement to determine what the statute means. And having read that statement by the sponsor of the bill, the very person who kind of drafted the bill and is the champion for the bill, the judge will think, well, Well, clearly, the whole purpose of this, the intent of the legislature, was to make this a beautiful park for horses. Therefore, horses are not pets for the purposes of banning pets from the park.
Legislative intent's one of those things that sounds good in the abstract. I mean, you read that and you're like, oh, that makes perfect sense. Obviously, the legislature, they're the ones passing the law, so why shouldn't you look to what they think? But you can imagine how easily this is manipulated. So number one, who matters the most? So this is the sponsor of the bill. So he seems important, right? But at the end of the day, his vote counts the same as everybody else in the legislature. So what if some backbencher gets up and says, yeah, I'm going to vote for this bill because the way I read it, it's going to ban horses. Do you say, well, he wasn't the sponsor, so he's not as important? Well, what if, the committee chairman says something different? Or what if the opposition leader or the majority leader or the Speaker of the House say something different about the law? And you can imagine how this can also be manipulated. So you might, for instance, have somebody who tells somebody, hey, look, the bill does X, but I'm going to say it does Y on the floor just to make my constituents happy. So what does the bill actually do? Does it do what it says, or does it do what a politician says it says on the floor? And the other problem is it doesn't stop with the legislature. Sometimes you'll see executive signing statements. So the executive has to sign the bill. And they'll do things like say, I'm so happy to sign this bill, which finally will keep horses out of the park. And then what effect does that have? And so you can see why this, although it seems like a good idea, it can really be manipulated in the actual process.
And notice, by the way, how each of these theories that we're explaining to you leads to an outcome that may be different than what the words of the statute actually say. So that's something, and it's different for every one of the theories that we've expounded upon so far. So keep that in mind as well.
Yeah, and each theory, I think you'll see they have their benefits and they have their problems. You might say that textualism's pretty strict, but at least the judge can't go running off saying that no pets in the park means all pets in the park. And pragmatism, they can be pragmatic, but it also gives them a lot of flexibility. Legislative intent, hey, it's nice to know what the legislature wanted, but the legislature can kind of game that. The last one we're going to talk about is living statutory or constitutional interpretation. And I say statutory and constitutional because this is one that you see in interpretations of the Constitution as well. And this theory says that statutes and constitutions, they may be informed by some of these factors we've discussed before, but at the end of the day, they should be interpreted by the needs of an evolving society. And so the idea is we don't want sort of the dead hand of the law hanging over us. If society is changing, then the way we view the Constitution or maybe the way we view certain statutes should change as well. And even if the specific language seems to lead one way, let's look at the real needs of society. So, for instance, if the park, there was a time when this statute was passed, people thought of parks as places that people went, and that was it. And you sort of enjoyed nature in isolation. And now society looks at parks as places where we want to bring our animals and we want them to frolic and play. And we want dogs in the park. And we want them, catching frisbees and bringing people together and all this stuff. And if you say because of that changing society, we're going to change the way we view the statute, then you could even imagine no pets in the park becomes all pets in the park. You just basically kind of invert its meaning, or at least pets within a reasonable limit. And so you can see how this interpretation can really change what might have been a longstanding meaning of a statute or constitutional provision to reflect, I guess, the views of a current society, not necessarily the people who passed the law or the constitutional provision in the first place.
We just explained several theories of construction to you, but in addition to these theories of construction, there are canons of construction. These are used by judges to interpret the law. Now, some of them rest on the theoretical ideas that we talked about. So if you aren't an adherent to that theory, you wouldn't use it. But there are dozens of canons, and here are the most relevant. We're not going to go through every single one of them, but there kind of are a few that rise to the top of the most used canons of constructions by judges when they are trying to determine a case in controversy before them that depends on a statute. The first is the ordinary meaning canon. And it's exactly what it sounds like, that words are to be understood in their ordinary, everyday meaning, unless the context indicates that they bear a technical sense. In other words, laws are written for the people, and so those words should mean something to everyone, kind of society, what they understand it to be. So it's not some special legal term that has some highly technical meaning that no one actually understands the word to mean in everyday usage. What this is trying to say is the laws are for the people, should be interpreted by the people in terms of how they understand that law to be so that they can be governed by the law.
And in law school, there's this chicken statute. Alice, I don't know if y'all talked about the chicken statute, but there was a statute governing chicken production. And it was interesting because the meaning of chicken in the statute was not your typical meaning of chicken. It was the meaning of chicken that was industry standard. So industry standard for a chicken, if you use the word chicken, you were talking very specifically about a certain age, a certain weight, like all this other stuff, right? So when they used the word in the statute, because it was an industry standard, the word actually meant something different from your typical meaning. But otherwise, unless you have that, when you have words, we're not going to assume that they have some super special meaning. Laws are not supposed to be mysterious. They're not supposed to hide the ball. You're supposed to, as an ordinary person, be able to look at a statute and, if you really think about it, figure out exactly what it means.
Now, another one similar to this, a slightly different, is the fixed meaning canon. Now, this canon says that words must be given the meaning they had when the text was adopted. So not how ordinary people understand it today, but what it meant when it was adopted. So this kind of pushes against the living statutory interpretation where words can change over time. This is saying, no, it was adopted, and what the legislatures voted on, that is the heart of the statute and should stay the same, even if words have changed meanings over time.
And that's one where, obviously, if you're a believer in a more of a living interpretation or pragmatic approach, you're probably not going to use that canon. And so, we talk about these canons, and in law school you talk about them, and there's always this sort of, how useful are they? Do they just kind of reaffirm what you already want to do? You want to present them as if they are, everybody agrees on them and they're independent, but there is some controversy even about the canons themselves, but not all of them. And I think a lot of ones we're going to talk about are pretty well agreed upon. One of them is the negative implication canon. So that means that the expression of one thing implies the exclusion of others. And this is our first Latin phrase, because a lot of these are expressed in Latin phrases. This is expressio unius est exclusio alterius, and it's often just called expressio unius. An example of this: dogs, cats, and horses are not allowed in the park. Because you have specified what's not allowed in the park, it's not like pets. That means anything that's not a dog, cat, and a horse is allowed in the park. So if you want to keep everything else out, you better use a more general term, or you better be pretty exhaustive about what you're saying can't be in the park. There's also the unintelligibility canon, which I like to call the give up canon. This is one where basically, if Congress or a legislature passes a piece of legislation that is so poorly written that you cannot figure out what it means, it just goes away. It's just inoperative. We don't even worry about it. We don't even look at it. A good example of this might be, so the Ninth Amendment to the Constitution, I believe it's the Ninth Amendment, is often said to be an ink blot in the Constitution. And this is a pretty universal view, both right and left. Really doesn't matter where you come from. Nobody can figure out what exactly the Ninth Amendment is supposed to mean. And so no one applies it. It just sort of doesn't exist, even though it's literally in the Constitution. It's one of the first 10 amendments. It's one of the Bills of Rights. Nevertheless, because we can't figure out what it means, we just kind of gave up and have stopped. Then there's the punctuation canon, which says that punctuation is a permissible indicator of meaning. And this is the old commas matter thing. Those of you in the eternal debate about the Oxford comma, it's, we invited the strippers, Kennedy and Stalin, versus we invited the strippers, Kennedy and Stalin. And one of those, we have two world leaders and some strippers. And then the other one, we have two world leaders who are strippers. So the commas can matter.
I'm sorry. Yes, I abide by the Oxford comma, but also I love commas. I love punctuation jokes, and that's hilarious. We invited the strippers, comma. Their names are Kennedy and Stalin. Okay, now we're just really nerding out, but I think punctuation matters. Now, we'll move on with our canons of construction and not get bogged down with commas. Another canon of construction is the presumption of consistent usage. And this is that a word or phrase is presumed to bear the same meaning throughout a text. So a material variation in terms suggests a variation in meaning. So the word person is going to mean the same throughout the statute every time it's used. It doesn't now all of a sudden mean, persons and animals, for example. And you can see why this is attractive as a canon, because if you're writing one statute, you think the same word should have the same meaning throughout the statute.
And a lot of these really should be common sense. I mean, this makes sense, right? And you see this actually become important sometimes, where there will actually be debates about whether or not a later statute passed using a word means the same thing as maybe a statute that's been around for a long time. And so you can see how this might be important. So say 100 years ago, a statute's passed that uses a word. We'll go back to our sort of words have their meaning when they're enacted. But what if the meaning of the word has changed, and then later on, 100 years later, Congress or a legislature passes another statute and they use the same word? Then you have this interesting argument you're going to have in the case. One side's going to say the word means the same thing throughout. So that's the meaning. It was the meaning of the word in the first part of the statute. It's the meaning of the word in the second part of the statute. The other side's going to say that's true. However, there's also the canon that says words have their meaning that they meant at the time of enactment. And that word meant a different thing 100 years ago. So even though the words are the same, there is a material difference, and we can't interpret them the same. So these are the ways that these really sort of nerdy arguments happen in courts.
Indeed. Another nerdy canon is the surplusage canon. And it's that if possible, every word and every provision in the statute is to be given effect. In other words, nothing within the statute should be ignored. None should needlessly be given an interpretation that causes it to duplicate another provision or to have no consequence. And the idea behind this is that to pass legislation, there's a lot of thought that goes into the drafting. There's a lot of thought and debate going into it. And so when the legislatures vote to enact that statute, they mean every single word of it. There's not a particular phrase that doesn't really matter. If it didn't matter, they wouldn't have put it in the statute. And so you interpret, say there's a clause, you would not interpret that clause so that it's subsumed in another clause and that it would have no independent meaning. Another canon is the harmonious reading canon, and this is that the provisions of a text should be interpreted in a way that renders them compatible and not contradictory. So this is, again, common sense. It's one law trying to make sure that it all makes sense. And you can see why if there's no way to make the statute harmonious, then you have the kind of the give up canon, right? We have no idea. We've tried really hard to make this work together, and because we can't, then we give up. But generally, you're going to try to read the statute so that it can be read as one and it's harmonious.
So a good example of this, we've already mentioned it, the West Memphis 3 case, that whole habeas statute we looked at. So if you look at the habeas statute, everything about the habeas statute is about people who are in custody. We talked about this. Do you have to be in custody or not? And the judge said you have to be in custody. And the courts had said you have to be in custody. Well, imagine you didn't have the courts. Imagine you just had the statute. Nobody's interpreted it before. So it's going to be a matter of first impression. And you look at the whole statute and everything's like, you got to be in custody. You got to be in custody. You got to be in custody. Then there's one provision that talks about a mechanism for someone who's not in custody. And people grabbed onto that to say, see, you don't have to be in custody because of this one provision. The problem is if you read it like that, it doesn't make any sense with the rest of the statute. Everything else is talking about how your power is limited to when people are in custody. So what does that mean? Well, it turns out what it actually means, and you could figure this out if you really looked into it, is somebody who's in someone else's custody. So you're still in custody, but you're in custody of like the state of New Jersey. And so in Arkansas doesn't have custody over you. So they need a provision that allows them to get custody over you. And then the rest of the habeas statute can go into effect. And once you look into it, you can figure that out. But this canon of interpretation signals to you that's not going to be what it means. Because if it means that, then it's not harmonious and the whole thing kind of falls apart. And it tells you, think deeper, look deeper, figure out what this must mean. In that case, you found an interpretation that in fact makes the statute harmonious. So then there's the general versus specific canon, which says if there's a conflict between a general provision and a specific provision, the specific provision prevails. And so you'll see this sometimes. I wish I had a good example of this one, but it's just there are a lot of very broad statutes that have been passed over the years to give sort of general guidance to courts. And then a lot of times, some legislature will decide, well, I don't really like how you're interpreting that general statute, so we're going to pass a law about a specific instance to make sure that when this thing happens, you do this thing, right? So if you have those two statutes, originally all you had was the general one. And as a judge, that gave you great power to do things. Well, once that specific statute gets passed, your power is now limited. And if it is one of those circumstances, you can't point to the general provision to do whatever you want. You're going to have to follow the very specific law.
Guys, we're reaching the end of canons of construction. And Brett, it was really funny. I was like, oh, we're almost near the end. I don't know if we've talked for long enough. We've been talking for like half an hour. How is this possible? This really proves we're nerds.
No, I mean, look, I'm restraining myself. I don't know what you're talking about. I could talk about this stuff all night
long.
No,
I am too. This is going to be in the outtakes, but like Brett and I are like holding by ourselves back, being like, okay, I'm going to hold back commentary because we have 10 more canons of construction to go.
Exactly.
Okay, we only have 2 more, though.
We do a follow-up one day after this is our most popular episode.
I truly think it is incredibly important for people to at least have familiarity with these so that they can intelligently articulate why they disagree with a particular ruling. Because all of them, they all stem from reasonable argument.
And you can see why people disagree, because even if you look at the canons and the theories, they contradict at points. And so, and this is a good point Alice brings up, and I'm glad she brings it up, because a lot of times you'll see a ruling, and people who don't agree with it will just act like, well, the judge must be corrupt. And you saw that in that West Memphis 3 case. People acted like, well, if the judge ain't going to test the DNA, she must be corrupt. She's on the take. She doesn't know what she's talking about. And no, she came from, actually, she was absolutely right, number one. But number two, she's coming from a place where she's interpreting a statute based on how she's been taught, based on the laws and the rules of Arkansas, and that's what she's doing. And when you see this, at least, even if you disagree with it, you at least can see why people do what they do. And I think that's important because most of the time, people aren't corrupt and they're not doing things from a bad place. And I feel like way too often, particularly these days, we just assign bad motives to people whenever we disagree with them. And a lot of times, that's just not what's happening. So anyways, I'll get off my soapbox and finish this canon thing.
It's helpful to know why this matters.
It is. One of them that's really important, and you actually see a lot, is the Is Judium Generis canon, which means where general words follow an enumeration of 2 or more things, they apply only to persons or things of the same general kind or class specifically mentioned. So imagine if you had a statute that said no animals are allowed in the park. That's pretty clear, right? And it's very broad. No animals are allowed in the park. If you see a squirrel, you got to shoot it or whatever, right? So that's the law. Well, imagine instead of that, you have one that says dogs, cats, and other animals are not allowed in the park. Well, now you have a class of animals which is much more narrow. Now it sounds more like no pets in the park because the specific animals, remember the specific governs the general, the specific animals that were listed are pets. And so when you're interpreting animals, even though animals normally would be very broad, now you're going to interpret it much more narrowly, and you're going to look at whether or not the animal in question is of the same kind as the specific animals that were prevented from entering the park.
So that doesn't sound like you need to shoot a squirrel or a chipmunk if you see it there, because they don't really fall in the realm of dogs and cats as domesticated animals. Now, another canon is the severability canon. This is important because if a particular clause or provision of a statute is unconstitutional, it cannot stand, right? But what this canon is saying is that you can sever off the part that is unconstitutional, and the rest of the statute survives if the court can effectively cut off the unconstitutional part of it. And the purpose of this is recognizing that it takes a lot of time and thought to pass statutes. And if you can save a statute without just scrapping it whole cloth because, someone kind of put something in there that was just obviously unconstitutional, but the rest of it is fine, you try to save that, the rest of the statute, and kind of not just scrap an entire legislative action.
And a really famous example of this is the Affordable Care Act, or Obamacare. So there was a big argument about that piece of legislation about whether or not the individual mandate was constitutional. So this is a massive piece of legislation. It has all sorts of provisions. It does all sorts of things. But then there was one provision that was like a funding provision, basically, that said from now on, the government is going to command you to purchase insurance. And this was like a big deal because the federal government typically, there are some state laws that do that. Like you have to have insurance to drive, for instance. But there weren't very many federal laws that said you have to buy this thing. And it became really controversial. And there are all these fights about it, about whether or not it was a violation of the Commerce Clause. It ended up getting called a tax. And because it was a tax, it sort of survived, but eventually it got repealed anyway. But in any event, one of the arguments was, say it is unconstitutional. Say the government can't do that. Can't tell you to buy insurance. Well, what happens then? Does that one part of the legislation being unconstitutional bring down the entire thing? Or is that just going to be severed out of that? Just that is unconstitutional. Now it's as if it's not even in the statute, and the statute's going to continue.
And by the way, the statute is like thousands and thousands and thousands of pages long.
And the argument against severability in that case was, yeah, but this is the most important part, because without this, all those thousands of pages depend on the funding that's going to be generated by everybody having to buy insurance. A lot of people don't buy insurance, but because they were having to buy it, that was going to create a pot of money that was going to allow insurance companies to cover people who ended up not having insurance. So it was this sort of big picture thing where we're going to make sure everybody has insurance and we're going to pay for it through this. So if you knock that out, it's not just one part. You're taking out the whole funding thing. Now, I don't think that argument was ever going to work. It ended up, we didn't really find out, but I would be very surprised if a court at the end of the day had struck down the entire legislation on that basis. And as we said, eventually that part was actually removed. That part was actually excised from the legislation anyway, and the legislation continues. So it probably was the correct decision, or would have been the correct decision, that even if it was found to be unconstitutional, not to strike down the entire law on that basis.
Okay, we have reached our last canon of construction, and that is imperi materia, and that is related statutes canon. So this says that statutes imperi materia are to be interpreted together as though they were one law. So the statute we are working with here today, no pets in the park, that's really not representative of what most statutes look like. Most statutes, go read a statute book. They might be at the library, but they are long, and they oftentimes have provisions that refer to other provisions of the law. And you have to, read other parts of the law in conjunction with the law to really understand what that law is trying to say. And this is just saying that you're supposed to interpret them together. So this is not unlike the harmonious reading canon, trying to make these statutes fit together. It seems very rational, but in reality, like what Brett was saying earlier, if you have laws being passed different, decades apart by different bodies of legislatures, different people who make up the legislature, sometimes it can be really hard to make them resonate with each other. But that is what your interpretation is trying to do. Make sense of all these related statutes together so that they are one coherent piece of law. So there you have it.
That really is the hard work of judges. The hard work of judges is you have all these statutes passed all these different times by different people from different parties with different political views for different purposes, and you have to make it all work. And Alice is right. The harmonious reading canon tells you if you have a statute, make sure it's, internally consistent. Read it so it's internally consistent. And this just says, and take that and apply it across statutes in similar veins. So if you're dealing with a bunch of statutes about, take criminal statutes, a bunch of criminal statutes about drug trafficking. All the different criminal statutes about drug trafficking, you need to read them together so they're harmonious. So if you have one statute that has some ambiguity and you can't really figure out what does this word mean in this particular statute, you look at all the statutes around it and you say, oh, okay, I see. Based on all these other statutes, this word or this phrase must mean this. And so that's how I'm going to interpret it. And I don't know, this stuff is nerdy, but I find it really fascinating. This is one of my favorite classes in law school. I really enjoyed statutory interpretation. But hopefully this has been somewhat enlightening for you guys when you are thinking about these things when this kind of stuff's in the news.
Indeed. So we've actually just touched the iceberg on all these different theories and canons of construction, but hopefully it gives you a working knowledge to be able to explain to your friends why certain courts interpret statutes certain ways and why there's debate. This is the beauty of it. You can see how much variation there is in all of these, and there is not one settled way of interpreting statutes. It depends on the judge, it depends on the situation. And this is why lawyers have jobs, really, to be honest, to make these arguments before the courts. So with that all said, Brett, do you have anything to add about interpreting statutes in this riveting episode of Legal Briefs?
No, I think I've said enough. And thank you to all of you who've been giving us ideas. And people did ask about this. So you may be shocked by that, but it is true. And we like talking about this kind of stuff. So if you guys enjoy this, man, we'll just keep getting deeper. Somebody's already asked us about a statute out of Texas that we're going to be looking at. And some of this is going to come into play. So buckle up. More statutory interpretation to come.
Indeed. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
This is so nerdy. We're going to do canons of construction. We're going to be saying some Latin terms. This is going to be amazing.
I won't say how I really feel about pragmatism, but we'll let that one go. I can't believe we talked for 45 minutes about this. I thought it was 2 minutes. To be totally honest, I was like, oh, this would have been a 15-minute episode. And I was like, oh, apparently I love talking about statutes.
I think fireworks are going off in the background. Flags waving. Is that the national anthem I hear?
No, it's God Bless America.